to start to begin the process of thinking about and looking at the different protective orders and how in some respects they're similar, in other respects they're different, and what are those differences, and under what circumstances would it be appropriate for someone who's experienced violence who wants a protection order, which protection order would be the most appropriate, what are the pluses and minuses, what are the options that you can convey to someone who's experienced violence, and of course with the ultimate goal of enhancing safety. So this week we're going to do a brief overview of what those different protective orders are. Also this week there's a true and false exercise for you to do, which will highlight those differences as you begin to learn the different protection orders. And there's also a video from an experienced advocate who talks about what the role of the advocate is. And we know that advocacy plays a critical role in helping victims of domestic violence pursue their options, understand their options, conveying information, what the pluses and minuses and risks and benefits of any particular legal proceeding might be, and also obviously to provide support, give them different resources, and help with safety planning. So there's a short video for you to look at from an advocate talking about the role of the advocate in protection order proceedings. And there's also a discussion question this week for you to think about with your course participants to discuss what the role of the advocate might be. Okay, so first of all, there are basically three types of protection orders available in Minnesota. There's the order for protection, which arises out of the Domestic Abuse Act, and probably the one you're most familiar with, and it arises out of the civil or family court or sometimes tribal court. There's a harassment restraining order, which focuses obviously on harassment, and that also arises out of civil court. And there's a domestic abuse no contact order, commonly known as a DANCO, which comes out of a criminal proceeding and comes from the criminal court. So the first question to ask is whether or not there's some sort of relationship between the parties that's needed in order for the person that you're working with, your client, for her to qualify for one of the protective orders. So with an order for protection, there is a relationship requirement, and there's a requirement is that the person and the respondent or potential respondent be part of a family or a household. And next week we're going to go into more detail about what that means, but there is a relationship requirement. For harassment restraining orders, there is no relationship requirement at all. And for DANCOs, because they arise in a criminal proceeding and only a limited kind of criminal proceeding, there is also a relationship requirement. So just very briefly, the standard, if the relationship exists for an order for protection, is that there be physical harm, bodily injury, or assault, or the fear of infliction of imminent bodily injury, harm, or assault, a sexual assault, terroristic threats, or interference with an emergency call. For the harassment restraining order, harassment is defined as a physical or sexual assault or repeated incidents of intrusive or unwanted words, gestures, or actions that either have the effect or are intended to have the effect of a substantial adverse effect on the safety, security, or privacy of another. And the DANCO, which again arises in the criminal process, if the defendant is being prosecuted for domestic abuse, stalking, or harassment of a family or household member, a violation of an order for protection, a violation of a previous DANCO, or a violation of a no-contact order, then a DANCO can be issued by the criminal court. Both the harassment restraining order and the order for protection do have an ex parte process. And the ex parte process, as you probably know, ex parte means one-sided, is if the person in an order for protection hearing states that they are in immediate and present danger of domestic abuse, the judicial officer will review the documents that she's filled out, make a decision about whether to grant an ex parte order or not. And of course the other side, because it's an ex parte process, is not present and can't present any arguments one way or the other about the need for the ex parte order. The harassment restraining order also has an ex parte process, and if the petitioner is in immediate and present danger of harassment, the judicial officer can issue an ex parte harassment restraining order. But the one thing to keep in mind is that for the order for protection, the ex parte process only grants limited relief. And that relief is limited to an order that restrains the person from committing acts of domestic abuse, excludes the person from the home or a reasonable area around the home, excludes the person from employment of the other party, the employment place of the other party. It also can order no contact. It can order that whatever insurance is currently available be continued, and it can regulate the care of and possession of pets. With respect to that limited relief, if that's the only relief that the petitioner is requesting, then unless the respondent asks for a hearing, no hearing is needed. If more extensive relief is requested under an order for protection, then a hearing has to take place within 7 days, and the ex parte order is good for 14 days. And the relief that's available under an order for protection is fairly broad. Not only in terms of a full hearing can there be all of the restraining elements that I talked about before, and excluding the person from the home and place of employment and a reasonable area around the home, but also can provide a temporary order of custody, a temporary order for child support, a temporary parenting plan, and it can temporarily divide up property if that's needed. It also can request or order the respondent to surrender firearms under certain circumstances. Now, the harassment restraining order can be an ex parte order, but again, relief is quite limited to ceasing the harassment and no contact. And even with a full harassment restraining order hearing, that also is the relief that's limited to harassment restraining order process. Again, with the harassment restraining order, if the abuser or the harasser does not request a hearing, then that ex parte harassment restraining order becomes the more permanent order. So, how long can these orders last? Well, there's quite a bit of similarity here with respect to the OFP and the harassment restraining order. The order for protection, the initial order, can last up to 2 years. If there have been 2 previous orders or 2 violations of orders, and it can be requested to last up to 50 years. The harassment restraining order can last up to 2 years. And again, if there have been 2 previous restraining orders or 2 previous violations, you can request that it last up to 50 years. For the domestic abuse no contact order, that's different. Because it arises out of the criminal process, if it's a pre-trial order, it lasts as long as the criminal proceeding. A domestic abuse no contact order can also be a post-conviction probationary order. And if it's ordered as part of post-conviction probation, it then will last as long as the probation lasts. Another important aspect of the order for protection is that there's a separate provision in the statute that deals with subsequent and extensions of orders. And this is important because the standard under which a subsequent order or an extension of an order is granted is different than what you need to show to grant the initial order. And the standard for extending an order or a subsequent order is if the abuser has violated the order, if the petitioner is in reasonable fear of physical harm, if the respondent harassed or stalked the petitioner, or if the respondent is incarcerated and about to be released. So you can see from this standard that there's no need to show a new assault, there's no need to show an actual injury. If her fear is reasonable, that's a statutory standard that would allow the court to grant an extension or a subsequent order for protection. Both harassment restraining orders and orders for protection do have provisions to allow minors to obtain orders under certain circumstances. The circumstances for the 2 statutes are different. For an order for protection, if the petitioner is 16 years old or older, and the court deems that she is mature, and the request for the order of protection is against a spouse, a former spouse, or someone with whom she has a child in common, then the court can issue an order for protection on behalf of the minor. If the minor petitioner doesn't meet any of those standards, then a parent or guardian or an adult over 25 would have to petition on behalf of that minor who's being abused. For the harassment restraining order, a parent, a step-parent, or a guardian can petition on behalf of a minor who's experiencing harassment. With respect to filing fees, there are no filing fees for petitioners and orders for protection. For harassment restraining orders, there's no filing fee for the petitioner if the petitioner is alleging sexual assault or stalking. And for the domestic abuse no contact order, again, because it arises out of criminal court, there would not be any filing fee involved. The provisions with respect to how these orders get served there are some similarities and some differences. For the order for protection, it's supposed to be served personally. If that can't be done, then it can be served by publication, or there's an alternative service provision in the statute which basically under certain circumstances allows service by mail. And there's also service through a process called short form notification. And the short form notification is a form that's issued by the state, and if a law enforcement officer happens to pull over a respondent on a traffic stop or has some other encounter with a respondent and checks the register and sees that this respondent is the subject of an order for protection, they can serve that respondent with a short form notification that informs that respondent that there is an order for protection and that he is instructed to go to the law enforcement office or the court and pick up the full order for protection. A harassment restraining order is to be served personally also, or if that's not possible, by publication. And with the DANCO, since it arises again in the criminal court, either at a pretrial or post-conviction, there's no issue with service because the defendant is right there. So what's the process for obtaining an order for protection? And again, I would refer you to materials. There's a flow chart in your materials. But just very briefly, if someone comes to your agency or perhaps they've been referred by law enforcement, you may help them fill out the necessary paperwork, which would be a petition and order, an ex parte order, an affidavit. There might be a law enforcement information sheet, which helps law enforcement get information for service purposes. There might be a petitioner's information sheet. Those papers are filled out. If she's requesting an ex parte order because she's in immediate and present danger, the judicial officer would review those documents and make a decision whether to grant the order or not grant the order. Then the papers get filed in a court data set. Even if the judicial officer decides that immediate and present danger standard hasn't been met, the petitioner does have a right to a hearing because, again, the standard for granting the order for protection at a hearing is different. It is not immediate and present danger. And so if that ex parte order is not granted, she still has the right to go into court to request an order for protection. The sheriff will serve the papers, a hearing date is set, and if the relief requested requires a hearing or if the respondent requests a hearing, then a hearing will take place and the judicial officer will make a decision about whether to grant the order or not. So that is a brief overview of the three kinds of different orders that are available, some of their differences, some of their similarities, and we'll talk about that in more detail next week, but this just gives you an overview to start you thinking about what are these different orders like, what might be the benefits of some or the risks of